Court officer. Court officer. Court officer. Court officer.
ಏನು ಹೇಳಿ ಸರ್?
ಏನ್ ಇಲ್ವಾ ಸಿಟ್ಟಿಂಗ್?
ಇದೆ ಬರ್ತಾರ ಸರ್, ವೇಟ್ ಮಾಡಿ ಸರ್.
ಹೌದಾ?
The matter for posting or commercial appeal, I had filed the matter on 21st of March. Office objection where I had removed. The urgency is the matter may be posted for tomorrow.
When you have removed the office objections?
I had moved on Thursday.
When it will come? Will come tomorrow? Will come tomorrow?
Maharaj, I'm a 14%. Memo for review of urgency, memo for posting of EMI lot. Because while ordering the fresh inquiry with service matter.
In the pending matter?
It is a pending matter, my lord.
Go and file an application for listing.
The entire appeal memo is time barred. For respondent. Therefore, I am submitting for early hearing.
Pending matter?
Pending in the sense it is freshly applied, but we are submitting for the first time. Fresh matter it seems, my lord. He is appearing for respondent.
So let the matter come only, then we will hear you. What for you are moving memo? What for? Why you are moving memo?
We have submitted appeal memo itself is time barred, my lord.
Never mind. The application for condonation of delay is also there. For condonation of delay. Time barred doesn't mean that it is not maintainable. Defect can be removed. Let it come to the court, only then we will hear you.
Number 1. KB.
Petition law has been granted a quarrying lease minimum for 20 years, with effect from 2009. I have been transporting the mineral lot for the past from 2009. Now, Lord, the the road which is in the forest.
Come to the impugned order.
Lord, please. The impugned order is at page 30, please, Lord. The relevant portion is at the last 4 lines. Adjacent
Kindly
to
read the order, complete order, only then we can understand. We have not seen the order. Kindly place the order before us.
Please. It is at page 30, please.
Page 28.
30, the relevant portion is at page 30.
Unless you, what they have said, unless we will know it, we cannot only by seeing the operative portion understand whether the order is right or wrong.
Lord, now the endorsement.
Or you just wait, let us first read it, then only we can understand.
Please.
Yes.
But now there is a road, my lord, which is a government Muffat land, my lord. And an area of 10 acres has, my lord, has been denoted, has not been considered as a forest area. And in that 10 acres, my lord, 2 quarrying leases were granted in favor of some another applicant. Now that lease period of the quarrying lease has expired. For the past 20 years, my lord, the earlier the lessee was using this road, my lord. It's a stretch of about 400 meters and it is not notified as a forest. And Lordsmen now kindly see page 30, please, my lord. All existing footpaths going from village to village, from houses to houses.
It only says that if the road is to be constructed, used for transportation of product produced by quarry area, prior permission of central government has to be obtained.
No, what it says, my lord, I have been utilizing.
As per the Forest Act, that is the requirement.
As per conservation of Forest Conservation Act, my lord, I am not carrying on any quarrying operations in the forest area. I am utilizing that small stretch of road which is in.
If the road is to be constructed in the forest area,
I am not constructing, my lord. The road is already existing. Lordsmen now kindly see, if the road is to be constructed, I am not constructing.
whether for using
Used
that,
for you.
all right, if the road is existing, whether for using that road for the carrying out the produce of quarry area, whether any permission is required.
No, my lord, under section rule 148, my lord, the forest authorities can issue forest pass, my lord. That is, Lordsmen now kindly sees rule 148 of forest rules, my lord, says deals with the transport passes. No forest path shall cover more than one road irrespective of the mode of convenience, provided that the deputy conservator of forest may permit one pass to cover head loads or animal loads not exceeding 20, cart loads not exceeding
forest
5.
part
Its
has
destination is more than 5 kilometers from.
You have applied for any such permission?
No, my lord, we have not applied, my lord.
Then?
Now they have dug a trench, my lord.
Huh?
Now they have dug a trench.
You forget about trenches. First you apply. If they will give you permit to use that road, the road cannot be constructed without.
I'm not constructing a road.
You are that you do not want. You only want to carry out your transportation
Yes.
through the forest area.
Through the forest area.
No, for that pass is required. Permission is
pass is
required.
required.
You have not applied for it.
But I have requested, my lord, by umpteen number of representation, my lord, to remove
The
the
government
trench.
has to give.
No, my lord.
Who has to? Who has to grant the permission?
1 minute.
Central government.
No, the assistant conservator of forest.
This is 149 authorization to issue way permit.
Way permit, my lord, has to be issued by the fifth respondent, my lord, assistant conservator of forest. Maybe.
Section 2, that is what the endorsement says. The impugn endorsement says, or the order says, that you have to take permission under Section 2 of the Forest Conservation Act. So unless you show us that Section 2 does not apply,
Yes,
unless you show us Section 2 does not apply,
please, my lord.
the endorsement order is correct.
No, my lord, 1 minute. Last now kindly peruse page 110 for a moment, please.
Right. We are not on that. Page 30, the specific reason for which it is rejected is prior permission of the central government under Section 2 has not been obtained by you.
But that has not, that's not
The question is whether,
what the order says. My lord.
Kumar, question is
Please.
whether prior permission is required under Section 2 or
No, my
not.
lord. My respectful submission.
Please read the provision and show us why it is not applicable.
I will read Section 2 of Forest Conservation.
Right.
Before that, please, my lord. If my lord can see page 110, please.
110 relates to state government.
Yes, yes, 1
We are
minute.
not concerned with state government. We are concerned with applicability of Section 2.
That's true, my lord. Because, my lord, this road is in existence from 1935, my lord. 1 minute. My lord, kindly see page 110, please. The assistant commissioner says, my lord, I have been carrying on quarrying operations from
I don't know
2009.
whether you followed what we said.
Ah.
The reason for issuing this endorsement is prior permission is not
So that,
obtained.
my lord, under
So
section,
please show us prior permission is not required.
I will show that.
We
I
will
will
go as per the impugned order only. In the impugned order, it is said that you have not obtained the prior permission.
The facts are like this. Last, my kindly, 2 minutes time, my kindly.
Sir, we are not asking for facts, sir. We are saying the again we are repeating, third time we are repeating, impugned endorsement says you have not obtained prior permission.
Yes,
Either you obtain prior permission or show us why prior permission is not required.
section 2 may kindly be seen.
Right. 2 Roman 2.
Any forest land or portion thereof may be used for any non-forest purposes.
Read the starting non-obstante
Yes.
clause.
The-
Notwithstanding.
Notwithstanding anything contained in the other law,
Right.
for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, any order directing that any reserve forest
Leave that. Come to 2. That any
2.
forest land may be used for
or
non-forest.
portion thereof
The
may be
state
used
government
for
cannot
any
permit you.
non-forest purposes. My lord, this is correct.
The road is non-forest purpose, sir.
One minute, please. 1 minute, 2 minutes. What the government has, Karnataka has conducted a proceedings in respect of this. Lords will now kindly see the proceedings which is at page 149, please.
Shivkumar, road is a non-forest purpose.
Yes, road-
Within the meaning of section 2, subclause 2 of the Forest Conservation Act.
Please.
Endorsement says, unless you obtain permission,
Under section 2 of the Forest Conservation Act, neither I can transport nor construct any road.
therefore,
That is the order.
please obtain that and then approach them.
Yes.
Will not-
We can dispose of giving you liberty to approach the central government for prior permission as per requirement under section 2, subsection 2.
1 minute, my kindly. Milords may now kindly say, Milord. The assistant commissioner, while giving a no objection certificate, Milord, he says
Sir,
that the
central
applicant.
government, sir.
That's true.
Sir,
Milord. He has been utilizing that road for the past 2009. Milord. Now,
Sir,
Without
you
permission.
use that circumstance to get prior permission from the central government.
Yes.
1 minute.
Use that particular fact of long user.
Milord, it's very practically impossible to get
Well,
Milord, it takes 5 to
we
6
cannot
years.
grant you permission.
By the time the period of the quarrying lease itself gets expired. Now I have been utilizing the road for the past 2009. Lords may now kindly see the proceedings of the government of Karnataka.
We can't do anything, sir.
1
And we
minute.
will dismiss the petition.
One minute.
What else is the option?
Milord, the government of Karnataka, Milord, has conducted a proceeding under these circumstances, Milord. 1 minute, please. Milords will now kindly see page.
Not this case that this will not apply.
This is not.
One may kindly be seen, please.
Please don't waste time unnecessarily. We have understood your problem. But the thing is that one prior permission from the central government is required.
Yes.
Then we cannot say that without obtaining the permission you shall be permitted.
One department says, Milord, that there is a.
The department may say anything. We are not concerned. We have to go by law. How can we go against the law if the requirement is this? Then how can we say that you are not required to take up?
Under these circumstances.
Section 2 is a non-obstante clause.
Also, yes, Milord.
So unless that is complied with, and the words used are prior approval,
Yes.
not even approval. Therefore,
Prior
you have to take permission.
Lords, one minute. My lords may kindly see various proceedings of the government of Karnataka.
We are not concerned
Under
with-
these
We are
these
not
circumstances,
concerned with the state government's proceedings.
Page
This is the
149 may
requirement.
kindly be seen, Milord. 149. Constitution of Divisional so and so. Government of the Forest Conservation Act 1980. Central Act is enacted to conserve the dwindling forest resources in the country. Section 2 of Forest Conservation Act 1980 puts some restrictions on the de-reservation of forest or use of forest land for non-forest activities. These are the proceedings of the government of Karnataka. Milord, government of Karnataka, Milord, may now kindly see 151, please, Milord.
Sir, you approach the committee, sir. We'll grant you liberty. Approach this.
Yes,
committee.
Milord, if that is done,
That's all.
Please,
That's what we have been saying.
please.
Approach this committee. You approach this committee.
If you don't want to obtain permission,
MOE,
approach the
yes.
committee. But
Section 2 permission from MOE.
Mahendra, let him take recourse to such remedies available in law. Approach
Please.
the central government. Let him approach the committee.
Please.
Do whatever you want.
Please.
Right. In this petition, petitioner is sought for the following reliefs.
1 minute, Milord. Page 23. My prayer may kindly be seen, please, Milord.
Sir.
What I have read is
Sir,
direct.
you have a right to approach the committee. We can't
Please.
direct the committee to consider your contention.
Please.
Consider a claim because of section 2.
Please,
You approach the committee, you approach whomever you want.
please,
Central government or the
I'll be highly
In this
obliged.
petition, petitioner is sought for the following reliefs. Right. Third learned counsel for the petitioner, so and so. in addition to reiterating the various
petition has been filed seeking for them.
sought for the following reliefs. We'll dispose it up. Sought for the following reliefs, so on. Heard. In addition to reiterating the various contentions, learned counsel for the petitioner invites our attention to the impugned order as well as the other material on record in order to contend that the petitioner has that the subject road is being used by the petitioner as well as other adjacent landowners from how many years?
2000, from 1935. you know.
Long time.
From a considerable long time, and consequently, the impugned order directing the petitioner to obtain prior permission of the central government under Section 2 of the Forest Conservation Act 1980 is incorrect and erroneous, and the same deserves to be quashed. It is also submitted that in view of the committee constituted by the state government to consider user of forest land for non-forest purposes, the respondent number who has passed this order, the respondent number 3, respondent number 5 committed an error in rejecting the contention of the petitioner that the road was being used from a considerable long time for non-forest purposes, and as such the impugned order is deserves to be quashed on this ground also. Per contra, learned AGA for the respondent submits that in view of the non-obstant
1 to 5, 6 and 7.
1 to 5, 6 and 7 submits that 1 to 5 and 8.
7 and 8.
1 to 5, 7 and 8 submits that in view of the non-obstantive clause contained in Section 2 of the Forest Conservation Act 1980, which contemplates prior permission being obtained from the central government before the state government considers the claim of a person for using a forest land for non-forest purposes, the respondent number 5 was fully justified in issuing the impugned endorsement. It is also submitted that that's all. It is therefore submitted that the impugned endorsement does not warrant interference by this court in the present petition, and that the same is liable to be dismissed. Full stop. After having given anxious consideration to the rival submissions, it is relevant to extract Section 2 of the Forest Conservation Act, which reads as follows. Full stop. A plain reading of the said provision.
It is not his case.
Section 2 of the Forest Conservation. It is not the case of the petitioner that Section 2, the aforesaid Section 2 of the Forest Conservation Act does not apply to the facts of the instant case. It is also not the case of the petitioner that the road, that the use of the road is for non-forest purpose within the meaning of Section 2, Clause Roman 2 of the said Act of 1980. Full stop. Under these circumstances, in the absence of prior permission/approval granted by the central government before requesting the state government to consider to pass appropriate orders permitting usage of the land for the purpose of road, which is a non-forest purpose, we are of the considered opinion that the impugned order passed by the respondent number 5 does not warrant interference by this court in the present petition. Full stop. However, under these circumstances, we deem it just and appropriate to dispose of this petition without interfering with the impugned order annexure dated so and so, semicolon. However, liberty is reserved in favor of the petitioner to take recourse to such remedies as available in law, including approaching the central government and
Central government. It is the deputy commissioner to constitute district level committee.
including approaching the central government, state government,
Or any other
authority, committee, etc., for ventilation of his grievances, and if the petitioner does so, the concerned authority/government will take necessary steps to address the grievances of the petitioner in accordance with law.
Time made within a period of.
Sorry.
So you submit it, they'll do it, sir.
We have not entertained the petition, we have dismissed the petition. How can we do that? Usage of road.
Usage.
Instead of say road, road is covered under the non-forest purpose.
Last week, my lord was pleased to pass an order in identical matters. Similar orders may be passed in this matter also.
What is that order? Have you annexed?
No, my lord. This order is not. Sought for instruction whether they have disposed of the application or not.
If
Oh,
not
no.
already disposed.
If not already disposed of, this petition.
Directly consider the claim as
Paragraph 6.
appropriate decision. Okay. No.
Comma, if not,
If not ready. Disposed.
Para 6.
Hang on. This a correction we have made.
One 3 years.
Same.
Same.
Go and tell your senior that you have got 2 orders today.
We are one branch.
The petitioner is a successful bidder. You have the e-tender notification called with second respondent for extraction of sand in respect of 4 acres of land of Balyamundu village, Kodagu district. Lord. The second respondent has considered the grievance of the petitioner, and finally the petitioner is a successful bidder and deposited the earnest money. My lord.
You want the
Only for
restraint order?
representation, my lord.
this PIL is dismissed. So now the path is clear for them. They have considered the representation and pass on. Where is the PIL?
Whether they are considering it.
They are not considered, my lord. The representation was given by the petitioner on 18/1/2022.
What is the procedure for grant of lease?
My lord, the grant of lease, my lord, initially they have already entire the formalities have been done, my lord.
To be advertised and then they
Correct.
have to
That's
apply
right.
all those pursuits.
What he's saying is this
Now this
PIL.
PIL has been done.
That's-
Now whenever they will advertise and whenever they will start the process for the grant of,
Correct.
he may also apply, will be considered
He says no.
in
That
the
will not.
garb of representation. Now we will observe that they will, whenever they start the procedure, issue the advertisement, you may also apply. Your application would also be considered along with others, and appropriate decision would be taken.
Already.
Now this situation must have changed from earlier. Earlier they may have thought to grant lease, but now after so much of time, they may not. It may not be necessary that they may grant lease.
Because you already deposited the
cannot
amount of
insist.
2 lakhs crore.
In view of the amendment to the KMMCR
Then?
in the year 2020, all the sand disposal is through government agencies. Now the process of disposal is, procedure for disposal is changed.
Change,
In
no,
view of,
this is what we are saying now. In the change procedure,
Well,
you will
delay-
have to advertise afresh.
Without delay while issuing the license, you may have the rival claimants have filed the writ petition before the Samba court, my lord, and this Samba court by the order dated, my lord, dispose of the writ petition, dismiss the writ petition, my lord, page number 96.
Deposited.
That money, because now after the amendment procedure is changed, the first procedure has to
The
be,
right which is accrued in this.
that may only no right has accrued. Unless money they can take that. Whatever this. They may consider for grant of lease, and for that whatever procedure at present is required after the amendment, that has to be followed. You may also apply the earlier which you had applied and deposited the earnest money and all that, you can take back that
No, they are already
and
issued-
apply afresh because the procedure has changed.
They are already intimated the petitioner to deposit the earnest money, my lord, as per page number 25, my lord, annexure C.
That you can take back because earlier one was for.
Already 4 years is already elapsed, my lord.
Yes.
Because we have, they later only have deposited the amount, my lord.
After the change of procedure after amendment, now we cannot say that you follow the old rules. And whosoever had deposited the earnest money, only those cases shall be considered. That cannot be done at this stage.
Therefore, it won't be
Which is the provision under which in 2019 you were granted permission to carry out sand mining? Which provision under the rules? The 2019 order is in your favor, which was challenged before in the PIL. Just show us under which, show us the procedure prior to amendment and after amendment.
What is in their favor?
Correct.
You should have harped on that only.
Correct. I just find if there is a
हम लोग अपनी तरफ से पूछना पड़ता है उनके फेवर में मुझे.
Mahendra, what is the procedure?
231 TM. Yeah.
Pre-amendment, post-amendment. Just show us, no? 31
D.
T.
It's pre-amendment.
Pre-amendment.
31.
T. T. Page 125.
Disposal of sand.
So this has happened. Now this right, according to you, is taken away.
By
Because-
subsequent.
Amendment.
Thereafter,
Show us the amendment. No, in 31T, which is a subclause, see, kindly come to page 76 of the first, before that, page 76. Page 76, not of the book, of the
Fine.
file. Order.
Yes, sir.
Order. This is traceable to which provision? Rule 31T, is it?
31 T.
T subclause. W. Has to be W. It's not T, it's W. The grant is under W, isn't it?
T must be the procedure.
Procedure.
Not 31T, sir.
No, no, this order is passed under which provision?
31T.
Sir, which subclass?
31 W.
W.
You see the W? Grant, transfer and surrender of quarrying lease. It is grant. Then 31T is the procedure and this is granted under 31W. In any case, this procedure has changed now.
It shows which the
That
change.
amendment kindly show.
It shows the change.
This is the existing procedure now.
Yes. This came into effect from 5th May 2020.
Yes.
It should not go in that. It should be done. They can consider the grant and all those persons. No, this procedure.
Thirty-one ZB.
31.
ZB.
The coastal district, is it? Is this a coastal district?
Non-coastal.
Why are you reading ZB?
Tender come in non-CRZ area of coastal.
That's what. Which is the provision, Mahendra?
In non-CRZ.
The amendment text prospective not an effective.
Coastal district तो नहीं है ना.
Text prospective in nature, not retrospective.
We have not argued anything in your favor. We are trying to find out what is all there in your favor.
See, 31X. This is the only thing that is saved. 31X is the only saving provision. The rest of it is changed. The quarry lease which has been granted. Is there a grant of the quarry lease? If this is construed as a grant of quarry lease, then that is
Granted
saved.
what?
This is saved 31X.
ग्रांट तो है ही है क्योंकि ये कह रहा है परमिशन दे रहा है इनको.
In 31X it is saved. Sir.
तो carry out का क्या मतलब हुआ?
31X. Maybe continue. Saved. Mahindra. 31X saves this 2019 order.
The order is paid 76, whether it is covered under 31X.
Which has been granted through it. Now, lease has not been granted.
But permission means what?
Is this order, sir?
What is the means permission?
Now, we have to execute lease deed in favor of all, complying with all the formalities. If he
Carry out the
fulfills
same
all
binding
the statutory requirements, then we'll execute lease deed.
Objection, sir.
So that is a requirement. Lease deed. Whether the lease deed was executed? No. It was only permission.
Of lease. In between PI was filed. So we can't find fault with the party because of litigation.
तो तभी माना जाएगा जब लीज executed.
But if there is a stay order by us in a PIL, party can't be. Whatever we write may affect other examine it. To file objections.
That is why we are indulging.
Will say, sir. Learned AGA accepts, directed to accept notice for respondent. Heard learned counsel for the petitioner and learned AGA for the respondents. In addition to reiterating the various contentions urged in the petition and referring to the material on record, learned counsel for the petitioner submits that on 15/3/2019, on 15/3/2019, right? 19, the Deputy Commissioner has passed an order granting permission to carry out sand mining activity in 4 acres of area instead of 8 acres as per the e-tender notification dated 2/2/2017 in favor of the petitioner. It is submitted that before the said order could be implemented and
Or lease could be executed.
or lease deed could be executed in favor of the petitioner, a public interest litigation in WP 14975 of 2019 was preferred by one Shivappa and another, full stop. The said petition came to be dismissed on 11/1/2022.
आज इसका टाइमलेस क्या करें कैसे पराशर पे और दूसरे की भी फैली हुई है
14975 of 2019, the respondents are duty bound to execute a lease deed in favor of the petitioner in terms of the aforesaid order dated 15/3/2019 passed by the Deputy Commissioner. It is also submitted that the said grant of mining lease in favor of the petitioner is saved by the transitory provisions for auction sand blocks as contemplated under in section in rule 31X of the Karnataka Minor Mineral Concession (amendment) rules 2021, which came into force on 5th May 2020 after the Deputy Commissioner passed the aforesaid order dated 15/3/2019. Full stop. Under these circumstances, learned counsel for the petitioner submits that the right that stood vested in favor of the petitioner, wide order dated 15/3/2019, continues to subsist even as on today in view of section 31X of the said rules, read with section 6 of the General Clauses Act, and consequently the representations at annexure so and so submitted by the petitioner is to be considered favorably in favor of the petitioner. Next para. Per contra, learned AGA submits interim order state. Learned AGA submits that having regards to the undisputed fact that the aforesaid rules were amended with effect from 5th May 2020, the earlier procedure contemplated in rules 31T to 31Z are no longer in force, and consequently the question of considering the representation of the petitioner does not arise. Full stop. In our considered opinion, the matter requires consideration. Correct, sir? Matter requires consideration. Learned AGA to file statement of objections by the next date of hearing. Released in June date.
The order of the DC is only to the effect to reducing the extent 7 acres to 4 acres, 9 acres to 4 acres.
Granted.
That is, he cannot. The granting authority is senior geologist.
Let us examine that.
26.
Here for the petition.
Validity of the rule. That.
Telling that also. Yes.
that petition and the validity of clause B of sub-rule 10 of rule 4, Karnataka Provincial Material Mining and Storage Mineral Rule 2011, which provides for events of royalty charges. But according to the petition, this is contrary to section 9 of the MMDR Act and also rule 39 now, earlier rule 64B, when the rule was in existence.
Sub-rule 10 of rule 4 is
Yes.
transportation of beneficiated mineral.
The 23C, that only it can frame the rules regulating the transportation of the mineral. Section 9, that is the one which
1 second.
is
Grounds on which this rule is unconstitutional. One by one, you should tell us.
one is section 9, the royalty will have to be paid at the mine head. Now this provides for collection of the royalty charges.
Shall be determined based on percentage of lump.
Right.
That this provides for their
Let us see that provision. Section.
yes, that's page 35.
Section.
Yes, I have produced that rule.
Right.
Section 9. Section 9 I have extracted at page 12.
Right.
Yes. The holder of a mining lease granted an hour after commencement of this act shall pay the royalty charges on the mineral removed, consumed by him or his agent, manager, employee, contractor, sub-lessee from the lease area at the time being specified in the second schedule in respect of that mineral. The holder of a mining lease, whether granted before or after the mining lease, regulation so and so, shall not liable to pay any royalty in respect of any coal consumed by a workman engaged in colliery, provided such consumption by this workman does not exceed one third of the consumption.
Now let us read this rule.
Yeah.
10B is it?
Just read 64B in the next page. Yes. Charging the royalty. Yes. If I process the mineral at the mine head, I have to pay on the difference of royalty. If it is not, that's in case of processing, run of mine is carried out within the lease area, then the royalty shall be chargeable on the processed mineral removed from the lease area. Then in case of run of mine mineral is removed from the lease area to the processing plant, which is located outside the lease area, then the royalty shall be chargeable on the unprocessed run of mines,
Sir,
not on the processed product.
This rule is there or it has been repealed?
Right, it was now it is repealed, now it has become Rule 39.
Right.
The same rule is there.
Right. Then show us the repealed rule. Then read the repealed rule.
Yeah, a repealed also I have extended.
Right. Rule page 14. Page.
Well, rule for this. In case of same identical ballot, it now become Rule 39.
All right.
In case of processing run of mine is
Right.
carried out within the lease area,
Right.
then the royalty shall be chargeable on the processed mineral removed from the mine lease.
Right.
In case of run of mine is removed from the lease area, the process plant in which the located outside
So where is the conflict, sir? Where is the conflict between 10B
Yes.
and Rule 39 or Section 9?
But it provides for levy of difference of royalty charges at the plant. I have to pay the royalty charges at the time of.
Kindly read, no? Because
Yes.
validity, right? So we need to understand.
Yes. Sub-rule 2,
Right.
in case of run of mine is removed from the lease area to the processing plant, which is located outside the lease area, then the royalty shall be chargeable on the unprocessed run of mine,
Right.
not on the processed product.
All right.
So now whatever this rule contains.
Now, please read the Rule 10,
Yes,
Sub-Rule 10.
yes, I will just. That also I have extracted is that page 8. In case of processing beneficiation, the royalty shall be determined.
No. Read the main. Read the main
percentage
rule.
of the lump
No,
recovered
read the
from-
main rule. Please read the main rule.
Yes, sir.
Any person intending to
Any person
transport.
intending to transport the beneficiated or a mineral ore stock from the stockyard to the destination within the geographic territory of India shall apply for mineral dispatch permit in Form 10 to the jurisdiction. That is not in dispute. In case of processing and beneficiation, royalty shall be payable to be determined based on the percentage of the lump recovered from the ROM. The difference of royalty amount shall be collected from the applicant before issue of permits. Now, this virtually runs contrary to repugnant to Rule 39 for the reason, here two minute one, it levies the royalty charges at the plant level. Now, royalty charges is required.
1 second, where does it say at the plant level?
Yes, it is recovered, but the difference of royalty will be only out in the plant only.
You're only reading the provision.
Yes, sir.
In case of run of mine, Rule
Yes.
39(2) is removed from the leased area,
Yes.
not within the leased area,
Yes, sir.
to a processing plant,
Yes, sir.
which is located outside the leased area. Royalty shall be chargeable on the unprocessed run of mine and not on the processed product.
Please.
So Rule 39(2) only says
Yes.
that the on which the royalty will be chargeable. That is, it will be chargeable on the unprocessed run of mine
Yes.
and not on the processed product.
Please.
Now, sub-rule 4 of Rule 10.
Yes, sir.
One is on what it is chargeable. One is the determination of the royalty.
Yes.
Both are completely different.
I pay the royalty charges and well in advance to the monitoring committee.
Sir, we are not on what you do. Sir. To
Please.
test whether this is unconstitutional.
It's unconstitutional for two reasons.
One second, sir.
Yes, sir.
You said Rule 39(2).
Please, sir.
39(2) only says
Yes.
on what it is chargeable.
Please.
Sub-rule 4 of Rule 10, that is B,
Please.
says the mode of recovery or rather mode of determination.
Please.
So one is on what it is chargeable, one is how you determine. Both are two different things.
And there's a bit. Royalty will have to be charged at the mining head. Once I remove the mineral from the mine head, the state authorities have no power to levy any royalty
We
charges.
are reading both the rules, sir.
That's true. Now,
You will have to show us,
Yes.
first of all, how sub-rule 4 of Rule 10 violates Rule 39.
the reason is that
Rule
now,
39 says what is chargeable. Sub-rule 4 of Rule 10 says, clause B of sub-rule 4 of Rule 10 says how you determine.
No.
There is a conflict.
that this is Rule 60. The Rule 39 states that I am required to pay the royalty charges on the unprocessed mine mineral at the plant at the mining lease. If I process it, I am required to pay.
Matter requires consideration. Sir.
Connected matter, your lordship,
All right.
19,773 of 2008.
Already notice has been issued.
All right. All right.
Only will connect it with this.
Let it AGA for respondents list along with
WP 19,773 of 2018.
right.
That is fairly covered by two judgments. Also.
That in this
I have
similar
given
matter,
those judgments.
notice has been issued to
LMDC
the
and Tata Steel case.
Advocate General on the challenge on the rules. List along with his petition such and such. In the meantime, let me read AGM is
19,773 of 2018.
Please write it down.
I'm writing.
all right.
Same minute, same two petitions.
Same order.
7.
Yes.
Petitioner had a fine lease for colored granite. Initially, the lease was given from 80 to 1985. Subsequently, it was renewed up to 2020. But I made an application to them that during the pendency, I was not allowed to conduct quarrying. So therefore, for that period, it should be extended. The authorities, without noticing, has given some reasoning which does not pertain to the issue at all. My application is because you did not allow me to conduct quarrying. To that extent, it should be extended. The mining lease is already extended up to 2020. The issued order is at page 52. Agenda 29. Section 8A proviso. Rule 8A. KMMC rules. Rule 8A proviso. Page 136, mining lease is already extended up to 31/3/2020.
Neither of the two conditions in the proviso are satisfied is what the endorsement says.
No, the endorsement does not say. Page 52, Lord, agenda number 29. The recommendation by the Director of Mines that up to 3 years it can be extended.
Agenda number?
Agenda number 29, page 52. Sir Krishna Swamy has applied for renewal of quarrying lease for an extent of 10 acres, survey number 8 in Nandi and village, so and so. Committee resolved to reject the application if the earlier lease period extended or expired on 8/10/85. Renewal application is filed on 30/8/96. No repeal rules came into force on 28/5/94. This is incorrect because there is already an extension at page 136. It is extended up to 31/3/2020. Now I made an application on page 140 that you did not permit me to carry out quarrying for about 12 years, page 147. Because of that, you should extend. The director will not recommend at page 203 that not 12 years, it can be recommended extended by a period of 3 years, page 205. From 28/12/2007 to 7/1/2011. The agenda is probably they have not looked into the papers at all.
You have to reconsider. You may have to reconsider.
The provision does not permit.
Not the provision, the facts. Facts have not been considered.
It's against law. Let me kindly.
All these documents which learned senior counsel referred to, those documents have not been referred to in the impugned endorsement. All it says is neither of the two requirements are satisfied, therefore conditions are satisfied.
Consider in 21st June 2021 letter is referred to in the impugned endorsement. My submission is not.
That is in their favor, no? Annexure AD is in their favor.
Their favor, but the very director issued this endorsement referring to 8A1 proviso 1. So last may kindly see the proviso reads thus.
We understood either the government should stop or the court order should stop. Only then it becomes what is this?
That can be extended only for 1 year, even in those cases. Only 1 year. And provided that the period of lease may be extended equal to the period.
Whatever.
If it exceeding 1 year for which?
Or any man.
Either you file your objections, we'll hear it, or we can set it aside, ask you to reconsider. Non-speaking order, no reference to anything else. There is a background, there is a history to this, isn't it? Everything has to be considered.
The director has actually recommended. He is
Correct.
not the endorsement issuing authority. He bases it on the Rule 11 committee's order.
Pass a fresh order.
Pass a fresh order. In this petition, we'll remand it. In this petition, petitioner is sought for the following reliefs. Please extract. Heard ಅಂತ ಮಾಡಿಬಿಟ್ಟು, in addition to ಅದೆಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು, learned senior counsel for the petitioner invites our attention to the impugned endorsement at Annexure A dated 25/10/2021/23/11/2021 in order to point out that having regard to the previous history of the claim, previous history in relation to the claim of the petitioner, including earlier orders, correspondence, etc., the same have neither been considered nor appreciated while issuing the impugned endorsement, which is a cryptic, non-speaking, laconic and laconic endorsement which has been issued without any application of mind and without reference to the aforesaid communication orders, etc. Full stop. It is therefore contended that the impugned endorsement is violative of principles of natural justice and the same deserves to be quashed. Full stop. Per contra, learned AGA for the respondents would support the impugned endorsement and submits that there is no merit in the petition and that the same is liable to be dismissed. Next para. As rightly contended by the learned senior counsel for the petitioner, having regard to the material on record, including the previous orders passed with the state government, correspondence, recommendations, etc., the impugned endorsement issued by the respondent number 3 is clearly respondent number 3 without adverting to or considering the same is an unreasoned, non-speaking and cryptic endorsement without any application of mind, thereby violating thereby violating principles of natural justice and consequently without expressing any opinion on the merits/demerits of the claims of the petitioner, on this short ground alone, we deem it just and appropriate to set aside the impugned endorsement and remit the matter back to the respondent number 3 for respondent number 2 for reconsideration afresh in accordance with law. After providing sufficient and reasonable opportunity to the petitioner and hearing him in accordance with law. Full stop. In the result, petition is hereby allowed, impugned endorsement is hereby quashed, matter is remitted back to the respondent number 2 for reconsideration afresh after providing so and so and hearing in accordance with law as expeditiously as possible and within a period of 3 months from the date of receipt of a copy of this order.
May I please, Honor? My lord, this case concerns the high security pit matter. Now, what has happened in the
connected
meantime?
matter because we've already withdrawn the tenders.
That is a difficulty, my lord.
That is recorded.
My lord, the difficulty is this. In view of the Supreme Court judgment of Maninder Singh Bitta, the only manner in which these contracts can be given is by way of a tender. My lord, may I kindly take my lord to that judgment?
Sir,
It's
Mr. Ayyappa,
Which matter you are?
who is Mr.
item 8, my
You are
lord.
informed that he will argue, we are not understanding, you will argue or he is arguing which matter.
Will become infructuous. Because I think similar matters we had noticed that it is pending before the learned single.
Yes, yes.
15 days back.
Yes.
That's it. In this
May I
petition,
submit-
petitioner is sought for the following reliefs. Full stop. Heard learned counsel for the petitioner and learned AAG for the respondents and peruse the material on record. Learned AAG has produced a copy of the order dated 29/3/2022, passed in WP 19114 of 2021, and points out that the impugned tender notification dated 1/10/2021 has been withdrawn on 29/3/2022. Is it?
Yes.
May I just cite, my lord?
29/3/2022. Submission, the submission of learned AAG is placed on record. Petition is disposed of as having become infructuous without expressing any opinion on the merits of the case. It will extract. The said order reads as follows.
My lord, I wish to cite a judgment, my lord, on this.
he is continuing to argue. Please.
I'm sorry.
So, matter my notes under the maintenance and welfare of parents and senior citizens act. Order that came to be passed by the Assistant Commissioner, my note. I think that I pay maintenance in the sum of 15,000 per month, and that I also be evicted from the premises. After my notes ultimately came to be challenged before the single judge.
Son and daughter-in-law troubling mother. Mother filed a petition under the Senior Citizen Act regarding possession and also maintenance. 2 sons and 1 daughter. Son has been asked to pay 10,000 rupees and possession, joint possession. Appeal dismissed. Petition Justice Dixit has said 35,000. They are saying that their trial, both the authorities said 10,000. Discretion. After all, mother. After all, mother. We can say we want to stay it. Let them come. We'll ask them to settle it. Settle it. Because old mother. If they want, they will settle it. But we no interference like that. Right. Yes. What is wrong in the order?
The order would indicate that I will have to pay 35,000 rupees per month as maintenance.
Yes.
In order, my notes.
Your mother or not?
I beg your pardon.
Your mother.
Mother.
Yes. You are litigating with your mother.
I beg your pardon.
You are litigating with your mother.
Unfortunately, my lords, and
It is not unfortunately, it is you who is responsible.
great humility, my lords, and I submit that some disputes essentially between the daughter-in-law and her brother-in-law. And I want to make certain statements here, my lords, but there have been certain allegations regarding the impropriety in conduct of the brother-in-law with the son's wife. That has, my lords, ultimately blown out into this dispute between the parties. It's not really one.
Both the impugned orders, the original order and the appellate authority, 2 reliefs were granted to the mother and mother-in-law. One is possession, one is 10,000 rupees per month. Right. Now the learned single judge has stayed the possession, not changed anything with regard to 10,000, but because of staying the order of possession, since she can't change enhanced, so it's a discretionary order.
I understand, my lords.
What is wrong?
I understand. The thing is, my lords, that under the Act as well, there is a stipulation that the maximum amount of maintenance that can be granted is that of 10,000 rupees.
Court can do that.
My lords.
226.
Court can enhance. They have ample of judgments.
I understand, my lords. There is a judgment of the learned single judge of this honorable court. They also indicate that, my lords, that it cannot be enhanced beyond 10,000 rupees.
If you want, we can observe that, go and negotiate and enter into sort of settlement instead of unnecessarily litigating.
In fact, I got on, my lords. I was, in fact,
We can observe that, but we will not interfere with the order.
In fact, my lords, if I may submit this, even I was going to make a mention before this honorable court that this is a matter that ultimately deserves to be settled as between the parties. The disputes are not as.
Go and settle with your mother and please her. She may pardon you and reduce the amount.
Or you allow her to live with you.
If I may make, my lords, in fact, this is not even.
But do all that before the learned single judge. This is a discretionary interim order.
If I can
only to ensure that she doesn't enter the house, admitted family house, right?
Yes, my lords.
She must be staying in the rented house or with the daughter.
May I make this submission, my lords? In terms of fact, this is a joint family property of the mother, son, and the 2 sons and the daughter. So they are staying together.
Two sons,
Daughter, of
one
course,
daughter.
stays outside.
2 sons, 1 daughter.
2 sons, 1 daughter. Daughter stays outside with her husband. The other two
Where is the
sons
mother
stay with
staying?
the mother.
Where is the mother staying now?
Mother, they all stay together. Currently, they're all staying together.
Why that order of? Why did you ask for stay then?
My lords, the stay was, my lords, against the order of eviction.
That's what, sir. If the mother is with you,
Please.
the impugned order does not say you have to be evicted.
In fact,
Show us the impugned order, the original order.
please.
She is the one who has brought you here. This word.
Page 70.
Enjoy the property.
Page 70.
Page 65 is the order of the assistant commissioner. It starts at 65.
Yeah.
And the operative portion, my lords, is at 70. Very, my lords. Petition is
Vacant operation.
exercising powers under 4 and 23 of the Act. This tribunal ordered to the respondent who want to hand over vacant position of the entire schedule.
He has to vacate, is it? He has to vacate.
Please. So an order of eviction has been made.
Vacation is not allowed, because there is that, to that extent it is a bad order.
It is a bad
But
order.
however, maintenance is concerned, Malars is right.
I'm
You see,
not
it is
even coming
duty,
in the
Malars.
way of-
There are a number of judgments, Malars. See, he can't, it is not that, Malars. It's a welfare legislation, he cannot, Malars.
I'm not coming in the way of
No, we'll
maintenance.
reserve-
I'm not even challenged the maintenance order, my lords.
This is,
Only
only,
the eviction.
this is only an interim order.
Yes, this is the final.
Please go before the learned single judge and request for early hearing.
Yes.
We won't interfere. It's a discretionary order. We can't interfere.
All I submit, my lords, is that because an order of eviction that is passed itself was an illegal order, and the learned single judge has rightly therefore appreciated that it needs to be
It's only an
stayed.
interim, it's not even an interim order. It's an interim arrangement. It's
Please.
an arrangement, right?
In fact, I was already paying 15,000 rupees, my lords, and that is an admitted fact. And that being the
How
case,
did
my
it
lords,
appeal
that-
is maintainable?
no, in fact, because it's not on the issue of
It's only an arrangement, discretionary interim.
It has been decided by learned single judge.
except my
How
lords,
unit appeal is maintainable.
just the order, my lords, the interim order now very clearly sets down the position of parties to state that unless I pay this money, I will be evicted from the premises, and that is the wording of the order.
Yes.
And therefore, my lords, while the order of eviction itself is illegal,
Go
Even
and
according to,
contest.
to attach a condition to that illegal order,
even
my lords,
according to you have to pay 10,000, right?
please,
So you go before the learned single judge, and adjustment can always be made. Instead of 35,000, you have to pay 10,000 is what you are saying. Even assuming you pay 35,000, in the future it can be adjusted.
I only
Get the main writ petition disposed of, because there's nothing, no observation or finding on merits. This appeal by the petitioners in WP 3592 of 2022 takes exception to the interim order dated 25/2/2022 passed by the learned single judge, whereby the petitioners were directed to pay a sum of rupees 35,000 per month to respondent number 1, Srimati Nirmala Patil, on or before the 5th of every month, including arrears of rent in terms of the impugned order. In terms of the order dated 21/4/2021, passed by the Assistant Commissioner and Chairman, passed by respondent number
5.
5. Failing which the said interim order passed by the learned single judge would stand vacated, rescinded and vacated.
Make one submission, my lords. Currently, I'm unemployed, my lords, and that is my issue.
Let him withdraw this. We'll ask him to withdraw this writ appeal. Don't.
No, this has been decided by the interim order, and as such, the writ appeal would not
Right.
deliver.
Right.
However, it is open for
For kind consideration.
We're not doing anything. Though next para, heard learned counsel for the petitioner and learned AGA for respondent number 4 and 5. Full stop. For the order proposed, notice to respondents 1 to 3 is dispensed with. Full stop. Next para. Though several contentions have been urged by the appellants before this court in the present appeal, as well as before the learned single judge in the writ petition, having regard to the fact that the impugned order is merely an interim arrangement made by the learned single judge pending disposal of the appeal, pending disposal of the petition, and there has not been adjudication of the adjudication/determination of the rival claims of both sides in the impugned order
or determination of any issue.
or determination of any issue that arises for consideration in the writ petition, comma, without expressing any opinion on the merits
No,
slash,
as such, we have to do
comma,
that. No, this
as
writ
such,
appeal is not
we
maintenance.
we are of the view that the present appeal against the impugned order, which is merely an interim arrangement, is not maintainable, and the same does not warrant interference by this court in the present petition. Full stop. We, however, make it clear that liberty is reserved in favor of the petitioner to request the learned single judge for early disposal of the writ petition and or take necessary
See modification of the interim order.
No, we are not saying anything.
And
or enter into settlement with the
respondent
court.
number one, having regard to the relationship between the parties and the advanced stage of the respondent number one.
May be permitted, my lords, to seek an alteration of the interim arrangement.
Who is that stopping you? Go and apply. Make an application.
Order should not be read in the.
Why we should say
should not be allowed to seek modification.
You are only saying that the writ appeal is not maintainable because there is no adjudication.
I understand, my lords. Please.
Office objections are there, ma'am, including maintainability.
So the 12th Supreme Court citation matter had come up. That time they had not challenged the review order. So they withdrew it. Now they have challenged both orders. Anyway, it is maintainable.
No, it is maintainable. Yes.
Last time, my lords, may kindly recollect, I come up before my lords where liberty was granted to pursue a challenge against the review order as well. This is now raised that is not maintainable.
26 है क्या? What is 26?
What's the
So the rule 26.
Please show us the rules.
Rule 26 of the Karnataka writ proceedings says that an order against the single judge's shall be designated as a writ petition. I think the objection is in view of the principles of CPC, my lord. Order 37, Rule 7.
Every appeal filed from an order publishing is writ appeal.
Well, that's. I think what they say is section 4, writ appeal only against intra-court appeal against interim order, against original order. Review is not original order, therefore.
Wait, single review, he will have challenge both.
They have challenged both.
Now they will challenge both.
It's correct.
What is wrong in it?
Nothing. We'll have to overrule the office.
Now you have challenged both the orders, original order as well as the review order. So the writ appeal would be maintainable.
My lord was pleased to refer the judgment in the earlier case, the other case, the other day.
2012.
Quoted.
Doesn't matter. We'll overrule.
Please.
January, an order was passed in which the Supreme Court has been pleased to observe that if my limitation period is expiring before 28/2/2022, in which this case is well falling under that, I get a fresh lease of 90 days.
Delay will stand condoned. We'll overrule both the objects.
Right. All right.
Now Now, what is wrong in the order?
Hello. There are three primary submissions, my lords, with respect to the validity of this impugned writ order. One, my lords, it is passed without jurisdiction. In that, it enforces, my lord, it was only a simple writ of mandamus before the learned single judge, questioning why a certain order which was passed by the respondent authorities has not yet been implemented against the appellant. Appellant here, my lords, is the secretary of the institution. She was respondent number 5 before the learned single judge, not represented in those proceedings. However, my lords, our contention is this. If I may kindly trouble my lords to take a look at the order that was sought to be enforced at the hands of the learned single judge. This is at page number 52, my lords. The memorandum.
You respond number 5 in the writ petition.
Learned AGA.
Office objections are
Office objections are overruled. Detailed orders. Office objections are overruled. Learned AGA is directed to accept notice for respondents 2 to 5. Full stop. Emergent notice to respondents 1, 6, and 7. Full stop. Relist after vacation.
One intelligence here. I have recently received a notice on the 5th, my lords, by the Deputy Director of the Department of PU Education, stating that to enforce the directions in the impugned writ order, I have to surrender my assets, my lord, and a list has been called for.
Meanwhile, respondents, the respondents 2, 3, 4, and 5 are directed not to take precipitative coercive steps pursuant to the impugned order dated 13/12/21 passed in W 25478 of 2018 till the next date of hearing.
But so far as
first week.
First portion of the order is concerned, that is already completed. Proceedings.
Sorry, any further precipitative? No, we are not. Any further precipitative / coercive?
That is already.
That's already completed. Our difficulty is the second PU exams are to begin from the case where the students who write the exam later are told that you have been through a college that has no recognition, therefore
We will decide.
Therefore, what I'm seeking is a stay on the order itself, my lords, in respect of the first portion also. There are 300.
We have not yet admitted the appeal. We have not admitted the appeal. In order to protect your interest, we have said that don't precipitate further.
Can I request for the order to kindly also incorporate that this should be the community of the students taking the examinations? That's what I'm.
We have already directed the institution to send them to other college to continue because it is derecognized.
Ultimately, this derecognition order is after the learned single judge passes.
Please, in compliance.
Like if we set aside the learned single judge's order, the derecognition order would go.
Certainly.
So status quo ante would have to be restored. Now, in the interest of the students, we'll have to permit them to take the
As of today, my lord.
as on. So shall we say status quo as on today?
As of today. Because
already received their hall tickets, my lord.
All right. Then we'll simply say, meanwhile, the impugned order at an passed with the learned single judge is stayed till the next date of hearing. Right. Reopening May last week. Right. We'll have to admit. Right. In addition to
consequential order.
shall we stay this order which you are now producing? Will that suffice?
No, that may not suffice that my learned friend rightly submitted that the recognition itself has been withdrawn.
Right.
This is post that.
No, the withdrawal of recognition, that will stay. Produce it along with the memo. Learned counsel for the appellant has produced a copy of the order dated so and so and submits that pursuant to the impugned orders passed by the learned single judge, the respondent state has withdrawn the recognition. The respondent state has passed an order dated 5/4/2022.
Only for transfer of assets.
my lord,
Show us the derecognition order.
Derecognition order is along with my IA for production of documents.
Where is that?
21/12/2021, document number 16.
Page number, ink page.
Sorry, 331.
This is dated.
That is dated 21/12/2021, my lord.
That's old order.
Old order.
It is an old order.
Old order.
It is not after that order, no.
Right.
It was before
As
that.
pursuant to single judge's order.
Madam, this order was there.
Single judge's order is dated
So
13/12.
we'll stay the single judge's order.
हाँ,
We'll simply stay the single judge's
फिर
order.
admit करनी पड़ेगी अपनी.
In addition to heard learned counsel for the appellant, in addition to so and so, learned counsel for the appellant invites attention to the impugned order dated 13/12/2021, passed in WP 25478 of 18 by the learned single judge, in order to point out that due to that the appellant herein, who was arrayed as respondent number 5 in their petition to the petition, could not appear before the learned single judge and contest the petition due to bona fide reasons, unavoidable circumstances, and sufficient cause, and this has resulted in the impugned order being passed by the learned single judge against the appellant. It is also submitted that having regard to the fact that the appellant has a good case to urge on merits and that the balance of convenience is in favor of the appellant, learned single judge committed an error in dismissing the review petition in RP number 335 of 2022, wide impugned order number 2 dated 7/3/2022, and this has occasioned failure of justice. Submission of learned counsel for the appellant is placed on record. Next para, next learned AGA adala baradu realist appeal is matter requires consideration. Appeal is admitted. Realist in first week of June 2022. Meanwhile, impugned order dated so and so passed by the learned single judge is stayed till the next date of hearing. Liberty is reserved in favor of the respondents to seek vacation/modification of this interim order.
Here delay is there, my lord, in this matter. Application is not filed.
Right in the beginning, the objections, office objections overruled, delay, stand condoned.
No application.
As per office order, as per office noting, the delay, stand condoned.
Notice to respondents 1, 6 and 7.
Emergent notice.
Number 12.
File this appeal, my lord, praying to allow my Section 8 application under the Arbitration and Conciliation Act. My lord, what has happened in this matter is the respondent filed a suit for recovery of money against me, arising under 3 agreements, my lord. If I may kindly trouble your lordship with a few pages, my lord, I would like to take your lordship through the arbitration clause. Kindly take page 37, my lord.
Section 8 application is rejected only on the ground that the time for filing written statement has expired. We've already said.
The 3 agreements, my lord, entered into between the parties. First agreement, my lord, kindly take page number 37, my lord. My lord, between the parties, the arbitration clause, my lord, is at page 46, my lord.
Emergent notice to respond. Heard learned counsel for the appellant. Should we record a small order, sir? And produce the material on record. In addition to the Labarbutu, learned counsel for the appellant invites our attention to the impugned order and submits that the commercial court committed an error in coming to the conclusion that the application filed by the appellant, Arbitration Act, appellant under Section 8 of the Arbitration and Conciliation Act 1996, bracket for short, the said Act of 1996, was not maintainable in view of expiry of the period of limitation prescribed for filing of written statement by the appellant in the suit. Full stop. In this context, it is submitted that having regard to several orders passed by the Apex Court extending the period of limitation on account of the COVID-19 pandemic, the commercial court committed an error in failing to appreciate that merely because the the period of merely because the period of limitation for filing the return statement had expired, comma, the said circumstance could not have been made the basis by the commercial court to reject the application under Section 8 of the said Act of 1996, which was otherwise maintainable in accordance with law. Full stop. Said submission of learned counsel for the appellant is placed on record. Issue notice to the respondent. List after service of notice. Meanwhile, all further commercial OS 324 of 21 are stayed till the next date of hearing. Liberty is reserved in favor of the respondent to seek vacation/modification of this order.
Prakash begin.
Does not receive the copies of the appeal memo. Some accommodation.
Settlement, money recovery set. Possible to settle this matter?
Pardon?
Is it possible to refer it to mediation?
I will try.
Because 15 lakhs is already
Recovered.
attached and deposited in court.
Yes,
Right.
6 weeks के लिए, 8 weeks के लिए.
Learned counsel for the appellant as well as learned counsel for the respondent, on instruction submits that there exists that the parties are ready to amicably settle the dispute between them. So joint submission is placed on record. Matter is referred to Bangalore Mediation Center.
May I make a sir? There is already execution pending in the Shimoga court. That may be referred before the mediation center in the Shimoga. So it
We'll
will
stay
be
the execution.
We will stay for 8.
My submission is to, just now I received the copy of the appeal memo. I may be given some opportunity to file my objection, statement of objection, because kindly see, 27/11/2020 is the date of the decree. The appeal filed is on 1/4/2022, after 2 years. And they are fully aware of the execution. They are participating in the
If
execution.
you are not ready to go to mediation, then we will stay subject to deposit of 50%.
Blood. For that, it takes some time, needs some time to make them.
Will stay. You don't precipitate the execution till the next date of hearing.
Please, that I can do.
Learned counsel for the respondent seeks time to obtain necessary instructions. Relist June alone date.
Considering the submission and
Full stop. Considering the submission made by the learned counsel for the respondent, the operation and implementation of the impugned judgment and decree is stayed till the next date of hearing, subject to the
Not
appellant.
precipitate the matter till the next.
Learned counsel for the respondent also submits that the respondent will not precipitate the pending execution proceedings, nor take steps to implement or enforce the impugned judgment and decree. The said undertaking given on behalf of the respondent is placed on record. Relist June on date. July 1 date.
Here, my lord, the petitioner challenging the validity of the notice under annexure A and B issued by the
Number 6 is not
DRI,
solved.
Directorate of Revenue Intelligence under section 28(4) of the Customs Act. The matter has already been settled by the Honorable Apex Court in Canada, India versus Commissioner of Customs, my lord. Annexure D. So, kindly for a moment turn to annexure D. Please.
Now, respondent number 6 has to be served.
My lord, that on the other day also I prayed that notice has to be ignored because of respondent number 5 notice has been served, my lord. He is the director of respondent number 5. That is why, my lord. I have on the last occasion also I have prayed for, but it has not been reflected in the order sheet.
it is not reflected.
It's not reflected, sir.
No, it has not been reflected.
Sir, R5 is a company. R6 is the managing director.
Managing director.
So you will have to serve him independently. You will have to serve him independently.
Since the notice has been served on the company, that is why I prayed for waiver of
It's a company, sir. You will have to serve. You will have to serve him independently, sir. He's an independent juristic legal entity. Please serve. 2 weeks time is granted to take steps in respect of unserved respondent number 6.
My lord, notice issued by the speed post, my lord.
Taken to file.
Yes, sought there.
Right.
Speed post.
Petitioner permitted to take steps through speed post. List after service of notice.
My lord, I am appearing for respondent number 1 in this case, my lord. My presence may be taken. Respondent number 1.
Right. Melgade, heard learned counsel for petitioner and learned counsel for respondent number 1.
My lord, date may be fixed, my lord. Since
All right. July 1 date. Right.
Number 50.
I appear for the petition.
Certified copy of impugned order is not filed.
No, my lord. Insofar as certified copy, insofar as certified copy of the impugned order is concerned, my lord, I have filed an application seeking for dispensation. And in IA number 1 of 2021, my lord, I had sought to implead the state of Karnataka, and there was an improper description of the respondent. Therefore, my lords have suggested me to file a fresh application. And accordingly, my lord, IA 1 of 2022 was filed. The office seems to have raised an objection stating that the prayers are one and the same. Then IA 1 of 2022, the proper. Sorry, my lord.
What is the impugned order?
Impugned order is, my lord, the levy of service tax on grant of mining lease or the royalty. My lord, the similar matters, several similar matters are pending. And in fact, may I request my lords to kindly turn to page 37, Annexure C. The similar levy was stayed by the Honorable Supreme Court also. The last para, my lord. Even our High Court, my lord, as per Annexure D. Annexure C, my lord, page 37, last para.
Is there any interim order?
Yes, my lord. Interim order was passed by the Supreme Court, not in this matter, my lord, similar circumstances, levy of service tax on the grant of mining lease or royalty.
We will simply connect this with that petition 13067 to 21.
Please, my lord. Annexure D. 148059 of 2020, Annexure D, Annexure E, they are the interim orders passed by this Honorable Court, my lord. It may be tagged with that, with the similar.
List along with WP 13067 of 21.
On the request of counsel.
At the request of learned counsel for the petitioner, list along with WP 13067 of 21.
Similar interim order may be granted, my lord. May I request, my lords, for grant of interim order in the same line, my lord.
So which interim orders?
My lord, the stay of that levy of service tax, my lord.
No, in the writ petitions, there is no clarity with regard to interim order being granted by this court.
It is there, my lord. Annexure D, my lord. Second page number 39, my lord. Page 39.
Correct, sir. Interim order granted by this court is not shown.
It is, my lord. Following the interim order passed by the Honorable, may I read, my lord? And even in Annexure E, my lord, at page 41, a very brief order referring to the earlier writ petition.
Correct. Sorry, I missed it.
Page 41 reiterates, my lord, referring to the earlier. By way of interim order, we direct that no further proceedings shall be initiated on the basis of the notices.
At request of learned counsel, list along with WP 13067 of 2021, full stop. Meanwhile, all further proceedings pursuant to the impugned show cause notice at Annexure F dated 38/21 issued by respondent number 3 are stayed till are hereby stayed. That's all, no, sir. Are hereby stayed.
My lords, may I make submission, my lords? The writ petition copies has not been served on me, my lords.
You'll serve.
I shall serve.
Please, my lord. Great.
Grateful, my lords.
Objection overruled.
addition, my lords,
Three is not
R3
serving.
has also, respondent number 3 has also filed a partition suit before the trial court, where the same property as this subject matter of this matter has been included in the schedule. And it will be permitted to serve the counsel appearing for respondent number 3 in the trial court as well.
It's a different litigation altogether, right?
No, because
Entirely, completely different.
Right.
by taking steps, the address,
You take out steps again.
in addition, my lords, as an additional.
No, if we say that, then you will come and say that notice served on the counsel in a different suit should be construed as notice being sufficient here. May not be right.
What is the difficulty in taking fresh steps?
We'll take that, my lords.
2 weeks to.
Counsel for petitioner pays further doubt, 2 weeks further time to take fresh steps with respect to service of notice on respond number 2 and 3.
It is a connected matter. my lords.
There are
16.1.
Okay, respond number 3, respond number 2.
both.
Right.
17.
Connected matter.
Service of summons, Lord. But we have approached the landlord. Lord, it is a recovery proceedings, rent recovery proceedings. But we have approached the landlord.
What is the service report?
Yes.
What, officer? Service report.
Council has also filed wakalat. Rajaram.
This also we thought can be referred to mediation if.
Please.
Where is Mr. Rajaram?
There, Lord. Yes. Just now, Lord, yes.
Okay. What else?
Password.
I appear on behalf of the respondent, my lord.
Asset reconstruction company under section 9, court not grants an order restraining us from enforcing our securities. But first of all, this is the matter which will not be subject to arbitration at all. We are entitled to proceed either under the DRT Act or under surfacing. For statutory proceedings, you are entitled to adopt, but cannot be injured by a section 9 court. Not about 1,000 crores is the default. Kindly not be here. Final order that is passed. Not should get that at page 77. Effect of this law is virtually are prevented from not exercising any of the powers under either the DRT Act or the Surface Act or not any of the provisions of law.
41B.
Please, 41B not also done. First of all, arbitration clause itself would be invalid not because Vidya told you not the Supreme Court says matters which fall under DRT not are not arbitrable.
Mr. Patil.
My lord, I appear on behalf of the respondent.
Ah, sir.
My lord, kindly see section page 77, my lord, that is being referred to by my learned friend.
Volume.
Kindly see the order, my lord. It does not restrain them from initiating proceedings in accordance with law before an appropriate judicial forum. It only says you should not take action on your own. My lord, what has happened is shares held in a limited company which are in demat form was offered as pledge. The apprehension, my lord, was that even when there was no default, they would sell it away. It is only limited to that extent that order has been granted, so you don't do anything like that. Kindly turn to page 77.
Sir, two grounds. One is section 41B of the Specific Relief Act.
No, that doesn't apply because 41B,
Right.
kindly see, there is no restraint against any judicial
Alright.
proceeding.
Then the arbitration clause itself, the arbitration agreement itself, what is invalid, is it?
No, my lord, it's not. It is not.
Page 69.
My lord, kindly turn to the arbitration agreement.
Sir, we are not able to hear you, sir. Raghavan, sir.
My lord, Your Lordship,
Audio.
are you able to hear me now, my lord?
I think so, you may have to push the mic a little bit nearer.
Yes, my lord. Now, Your Lordship, are you able to hear me, my lord?
Better. Right.
Page 69, my lord.
Please look at the order first, my lord, at page 77.
Right, sir. Sir, we are reading page 69, sir. Para 8.
Very well, my lord. Your Lordship may look at page 69 for a moment.
Right.
My lord, kindly look at the arbitration clause, my lord, that is there. That is 18.10 in brackets E.
Right.
Notwithstanding anything contained herein above, in the event of change in the status of the lender, or in the event of the law being made or amended so as to bring the lender under the DRT Act, or any other special legislation to enable the lender to proceed to recover dues from the borrower under the DRT Act, the arbitration provisions herein above contained shall, at the option of the lender, cease to have any effect. And if the arbitration proceedings are commenced but no award is made, then at the option of the lender, such proceedings shall stand terminated, and the mandate of the arbitrator shall come to an end, effective or the date when the lender exercises the option of terminating the mandate of the arbitrator, as the case may be. Now, my lord, please see, what is used, my lord, is that in the event of the law being made or amended so as to bring the lender under the DRT Act. Now, who is the lender, my lord? Please see, under the agreement.
Sir, 1 second, sir. Arbitration provisions herein before contained. Where is arbitration provision?
No, that is under 18.10. That Your Lordship may kindly see the documents, my lord, that has been filed. At page 102.
Because it's extracted, my lord, page 70. Your Lordship sees the clause, my lord, itself, Your Lordship, point 2.
So 18.10E is an exception to 18.10.
Correct. Now, my lord.
Right.
Lordships are right. 18.10.
Let Mr. Srinivas complete, sir.
Yes, very well.
So 18.10A is the arbitration agreement. Now, the section 9 is based on 18.10A. You rely upon 18.10E to say.
Talks about C. The original lenders, my lord, were L&T Finance. It was assigned in favor of, my lord, RC. RC is an asset reconstruction company.
Right.
But therefore, there is a change in status of the lender. Therefore, my lord, this would be a case where, at my option, my lord, I can put an end to the arbitration clause. In fact, my lord, I may point out, similar clause, my lord, in the case of Tata Capital, the Delhi High Court was interpreted to say, this clause, my lord, would not deny any mutuality in the provision. And therefore, this is not a valid arbitration clause at all. Not my lord, my submission would be, the trial court now says,
no, we will hear this. Matter requires consideration. We hear it. No difficulty.
In the meanwhile, clarify, my lord, it will not come since my lord, Senate Commissioner has said, it does not come in the way of any statutory provisions being invoked. But that will be clarified in the meanwhile, because he argued that what the final order does not come in the way of my statutory provisions. Your Lordship will record his submission, my lord, and clarify that in the meanwhile.
Sir, Raghavan, sir.
My lord.
We will have to hear this matter. So, what is the interim arrangement to safeguard the interest of both?
Please, my lord, in fact, this appeal can be disposed of on a short point. Please be kind enough to turn. Kindly turn to page 77.
Sir, my mistakes. Kindly push the mic a little far away.
Oh, I'm sorry. My lord, kindly turn to page 77.
Right.
I'm sorry, my lord.
Right.
May I read the operative portion of the order?
Right.
The respondent, its officers, agents, representatives are restrained by an order of injunction from in any way transferring, selling, alienating, encashing, and or disposing of or creating any third-party rights or otherwise parting with any security under the loan documents for a period of 90 days from the date of this order, or till passing of any order in this regard by the arbitral tribunal before the 90 days. Nothing in this present order shall be deemed or construed as any expression of opinion or observation by this court at the proceedings before the arbitral tribunal, which naturally will have to be decided on its own merits. Now, my lord, first, there is no prohibition against their initiating any legal proceedings. I mean, there is no need of a clarification. Secondly, my lord, if it is their contention that arbitration itself is
Correct. Has an arbitrator been appointed?
My lord, we have issued a notice. They have not agreed. We have filed a section 11.
Under section 16, let the arbitrator.
This was a case not which covered under the exceptions Vidya Dolia case.
Vidya Dolia.
Therefore, my lord, it will come under section 11 also.
CMP. In the CMP.
My lord, in any event, we have moved.
Any notice of any CMP, but if there we will be contesting the arbitration.
All right. Sir,
My lord, we have moved a section 11 petition before this honorable court.
Has it been filed, sir, already?
Yes, my lord, it is CMP number 110 of 2022.
So shall we say this, sir? Shall we say this, that we will clarify the impugned order by saying that this will not come in the way of the appellant doing what?
Exercising any of the statutory powers, not either Surface Act or DRT Act.
Exercising any of the
powers under Surface Act or DRT or initiating any other legal proceedings.
Legal proceedings and leaving open all, one second, sir, leaving open all contentions to be decided in the pending CMP.
Since Lordship said has to decide because under powers under section 9 will not I'm contesting.
Okay, so then we'll keep this pending.
Clarify because the order is
this pending and we'll only clarify the impugned order. We'll only clarify the impugned order that the impugned order will not come in the way of the appellant.
Exercising any statutory powers or initiating legal proceedings.
Or initiating any other proceedings.
My lord, I have no objection to this. Only a few words to be added. Statutory powers if available in law. Because according to me, my lord, they don't have the power, but let that be left open. It should not be, my lord, treated as if your lordships are giving them a permission to go under some statute in respect of it. They have no power.
All right, all right.
Powers under Surface Act, not all proceedings are clear.
Heard Shri Srinivas Raghavan, learned senior counsel for the appellant, and Shri K.G. Raghavan, learned senior counsel for the respondent, and peruse the material on record. In addition to reiterating learned senior counsel for the petitioner submits that the impugned order passed by the commercial court allowing the commercial AA number 201 of 21 filed by the respondent under section 9 of the Arbitration and Conciliation Act 1996 is illegal and vitiated in as much as the effect and impact of clause number 18.10E, clause E in brackets, to the arbitration clause contained at 18.10A in the agreement dated 30th March 2021. Illa.
That's the
My lord, that the loan agreement, my lord, is dated 26/9/2017.
26/9/2017
and 23/2/2018. There are two loan agreements.
And 23/2/2018 has not been considered in its proper
and the judgments in Vidya Dolia
perspective, as well as the fact, coupled with the fact that the decision, the judgments of the apex court in this regard have not been considered by the commercial court while passing the impugned order. Per contra, learned senior counsel for the respondent submits that a perusal of the impugned order clearly and the other material on record, as well as decisions of the judgments of the apex court and other high courts, will clearly indicate that the impugned order does not warrant interference by this court in the present petition. In the present appeal, per contra, before per contra, it is also submitted that the impugned order passed by the commercial court restraining the appellant, its officers, agents, representatives from transferring / selling / alienating / encashing / or disposing of or creating any third party rights or otherwise parting with any security inverted commas under the loan document s for a period of 90 days from the date of this order or till passing of any order in this regard by the arbitral tribunal before 90 days is coming in the way of the appellant exercising his statutory powers
under the Surface Act and from initiating legal proceedings.
Per contra, next part, liable to be dismissed. It is also submitted by the learned senior counsel for the respondent that exercise of the statutory remedies by the appellant would be subject to the said remedies available in law in favor of the appellant. Correct, sir?
Yes, sir. Yes, sir.
In this order, he also submitted, but this order does not come in the way. Your Lordship, my record is sufficient.
Full stop. It is also submitted by the learner. It is further submitted that the impugned order will not come in the way of the appellant exercising its statutory remedies if available in law.
And
Yes.
Remedies and legal proceedings and legal to be initiated in accord, if available in law. Next, the said submission of learned senior counsel for both sides are placed on record. Full stop. Matter requires consideration. Mele said submission munche. It is jointly submitted by the learned senior counsel for both sides that civil miscellaneous petition in CMP number
110 of 2022.
110 of 2022 has already been filed by the respondent against the appellant, and the same is pending adjudication before this court. And then go on to say joint submission is placed on record. Matter requires consideration. Appeal is hereby admitted.
My Lord, your Lordship may not admit the appeal, my Lord, interim order. Your Lordship may post it after vacation for hearing.
List during July 2022, full stop. Meanwhile, it is made clear that the impugned order passed by the commercial court will not come in the way of the appellant exercising its statutory remedies and taking recourse to such remedies as available in law, including initiation of legal proceedings, if available in law, pending disposal of this appeal.
My Lord, there is only one submission, my Lord. Then your Lordship will have to say, since it's your Lordship's order, this will not in any manner come in the way of CMP number 110. Your Lordship may not put that last portion, my Lord.
All right. It is further clarified that the present interim order will not come in the way, is without prejudice to the rights and contentions of the parties in the aforesaid pending CMP so and so.
Yes, great.
Yes, right.
Number 19.
Amendment is not carried out to the petition. Amendment is
19, I represent 9th respondent.
Appearing for the petitioner, my lord. The petitioner is the Karnataka State Legal Services Authority, my lord. Pertaining to the illegal transportation of children, laborers, and senior citizens, and other citizens in goods transportation vehicles, my lord. Pursuant to several directions issued by this honorable court.
Second office objection है.
Correct. Carried out. So
It is not carried out.
not carried out. You have to remove the office objections on the amended petition, madam.
You have to carry out the amendment physically. You have not done.
I apologize, my lord. May I request a week's time to comply with the objections?
The counsel for petitioner pays for is allowed 10 days time to make good the office objections. Just the month of July.
Obliged.
Number 20. GR Mohan.
For the matter pertaining to shifting of transformers brought from pavement. Yes.
Order passed on 31st March.
He had appeared not and filed an affidavit. There are totally the 8,659 transformers which were originally identified. Out of which 3,000 odd have been upgraded and shifted, which is mentioned in the objection statement also. Some 5,000 transformers were left, and with regard to that, the scheme had been prepared. There was a study by the joint committee of DPMP and the distribution licensee. Now the tender is called because the cost involved was more than 100 crores. And the tender has been awarded. Work has started from 1st of April for shifting of the remaining transformers. The fabrication work, everything is on. My request, is to have the matter after vacation. In the meanwhile, we'll update the Honorable Court with regard to the progress which we have achieved in physically shifting of transformers.
Compliance report. Additional.
The counsel for respondent submits that the work of shifting of transformers has started from 1st of April. And
time as per the contract, my lord, is 18 months including monsoon period. I have produced the letter of intent issued in favor of my lord, the contractor identified.
matter is taken up after summer holidays. We will show the progress made in this regard. On his request, case is adjourned today. List in the first week of July. The status report.
Status report to be filed by next date of hearing.
Yes. Now we have to tread a little carefully, my lord, in this period because examinations are on. Line clear, my lord, will become an issue. But
There shall not be any delay.
Number 21. Mohammed Iqbal, 14%. For responding 1 and 2.
Yes. Voting is a universal human right. Under Article 21 of the Constitution of India, housing is a fundamental right. Right to life includes right to reasonable accommodation to live in, right to pollution-free environment, right to live with dignity. Under Article 38 of the Constitution of India, states to secure a social order for the promotion of welfare of the people. My lord, the central government and state government, they are implementing housing schemes for various sections of the society. My lord, so kindly come to page number 71, my lord. This is about Pradhan Mantri Awas Yojana Gramin, Annexure A. The feature of the PM Pradhan Mantri Awas Yojana Gramin. Pradhan Mantri Awas Yojana Gramin aims to provide a pakka house with a basic amenities to all houseless households and households living in kacha and elaborated house in rural areas by 2022. That means central government is committed to provide housing to houseless people by 2022, and the unit cost of each house is 1.20 lakh, and the central and state share is at the ratio of 60:40. My lord, please come to page number 73, my lord. So this is about Pradhan Mantri Awas Yojana Urban. Pradhan Mantri Awas Yojana, housing for all, mission for urban area is being implemented during 2015-2022, and this mission will provide central assistance to implementing agencies through the states and duties for providing houses to all eligible families beneficiaries by 2022. My lord, similarly, the state government is implementing housing scheme for the below poverty line families in Karnataka. Page number 26, my lord. My lord, state government is implementing Basava housing scheme for rural poor who are living in huts and who are economically backward. And here the income limit is 32,000 per annum. That is a BPL family.
You have filed any statement of objection?
It is filed.
Yes.
And also filed November 2021.
What is the stand?
We have given details with regard to the schemes which are already being implemented and the houses which are already being provided. Fifth respondent has also filed one more statement on 8th December 2021, giving details with regard to the scheme which is provided to the nomadic also. Year-wise category, there is a list also produced. 2021, we have given the details with regard to the.
Thank you for the respondent number 4, and even I have provided details of the beneficiaries of all housing schemes which are being implemented by.
Respondent 1 and 2 has also filed objections, my lord, pointing out.
Have been floated by the state government and the board has done it. Everybody has done it. So the people are getting benefit of that. What can we do? What can only prayer?
all the three, that is Rajiv Gandhi housing, state government, then this backward caste, this one. All of them have said there are schemes. So what more can we do? They have said that. See the state government, then the Rajiv Gandhi Housing Corporation, then the Slum Development Board, as well as the Backward Classes Welfare Commissioner. All of them have said that they are in the process, or rather they have already formulated schemes and they are doing it.
Several schemes are there
Already
under
there.
which the houses are being provided to the.
Commitment on their part, my lord, because this is the last year of implementation of the housing. There are so many vulnerable sections of the society, so they are shelterless people, these nomads, then devadasis, orphans, physically handicapped.
Some procedures have been prescribed under those schemes. Whosoever has followed those
And there is no
procedures, fulfilled the requirements, they have been benefited. It is not your case that these schemes are not being properly implemented or some corruption is there under the implementation.
The retired director of backward commission.
We can only observe that respondent have said so many schemes are already floated and whosoever has applied and fulfilled the requirement has been benefited. So nothing more is required to be done by the court.
really help these poor people, my lord. So those
Well, people all right, but kindly show what wrong is being done. Show what wrong is being done. Nothing is.
All the schemes. There, along with their objections, the details of the schemes which they have already formulated, everything are given. Those details are there.
my lord, I will come to the objection.
No, we are not going to decide whether the schemes are implemented properly as on today. We don't know.
This is not his case also. Right. This public interest litigation has been filed.
For housing, my lord.
Will dispose of is filed seeking a direction to respondent to provide housing to eligible siteless / houseless urban and rural BPL / EWS families belonging to various categories of weaker sections of the society within a period of 1 or 2 years based on seniority, and to pass any such order in the interest of siteless / houseless urban or and rural BPL EWS families in Karnataka. The respondents have filed their statement of objections stating therein the various schemes launched by the central government as well as the state government for providing housing to the urban and rural BPL / EWS families. Full stop. The respondents have stated that under these schemes, whosoever who is eligible and fulfills the criteria prescribed applies, has been benefited and has been given the houses. Full stop. In view of above, we do not find any necessity to issue any direction to respondents to provide the houses to the BPL / EWS persons in the urban or rural area. However, it is needless to note that the schemes, various schemes launched by the central as well as state government shall be properly implemented, and the respondent shall ensure that the benefits under the said scheme reaches to the beneficiaries. The petition with this observation disposed of.
Number 22.
My lords, we are challenging the government order dated 25/9.
Statement of objection is
File, man.
Just filed it. I received it on Saturday.
file any rejoinder.
I'll file my brief rejoinder. My lords may take it immediately after vacation. It can be heard.
Counsel for petitioner may file the rejoinder affidavit to the statement of objection filed by government, additional government advocate, list in the first week of July.
For the fourth respondent, my lord. The lordship said directed the BBNP in this case to have a meeting with us. That meeting was held, my lords, on 8/4.
Hola.
We have now, my lords, given, they wanted a 6-monthly, fortnightly breakup of what steps you will take. We have provided that on 12/4/2022. We have not heard back from them thereafter.
Let him come, then we'll hear the matter. Huh? It is better. Pass over.
They may call a further meeting, my lords, if they have anything to say.
Let him come, whatever he says.
Some difficulty in the afternoon today, my lords.
We'll see before
Please, my lord,
lunch.
I'm so grateful. I'm so grateful.
We have been instructed to appear on day of respondent number 3. We have filed our wakalat today, my lord. I request that the case may be had after petition.
This service report.
Served. Served.
What is to be done?
Just to be carried out.
Yes.
My lord, petitioner has filed this petition alleging election in the duties of the respondent number 3 and 6, my lordship. 3 and 8, my lordship. Kindly see they have granted electric connection on a sale deed which has been entered for 100 rupees stamp paper, my lordship. It is a loss to the exchequer.
License issued by conducting inquiry.
These properties has been sold only on the paper of 100 rupees stamp paper, my lord. It is not been registered, and based on that, this one it has been recognized, my lordship, by the respondent number 3 and 6, and they have granted electric connection as well as the trade license, my lord, which is causing a huge loss to the exchequer, my lord. Kindly see page number 16, my lord. 17, annexed here, my lord. A sale deed has been produced. A type copy is at page number 19, my lord. $1,160 square feet has been sold on a paper of 100 rupees stamp paper. Stamp duty has been paid, my lord. And based on that, electricity permission has been granted as per annexure B, my lord, page number 32.
This, as per the DESCOM regulations or the ESCOM regulations, you can consider an unregistered document or an agreement and sanction, is it? Can you? Or is it mandatory that there is to be a registered sale deed?
I have to verify, my lord.
Sorry?
I have to verify, my lord. Apologies. Conditions are supplied.
Unregistered.
Of the matter permitting you to make a complaint to respondent number 2, and they will ensure that whatever are the requirements for the grant of electricity connection that should be fulfilled
My lord, one submission, my lord.
by the HESCOM or any other whosoever has done it.
Lord, as per section 33 and 34 of Karnataka Stamp Act, my lord.
We are not deciding any issue. We are not deciding. You say that without, they are deliberately avoiding to pay the stamp duty and granting the electricity connection. Now this complaint is to be considered by the state government and take a decision on that. This is a PIL, so we are not deciding any issue. This public interest litigation has been filed seeking following relief. The Counsel for Petitioner submits that the activities of respondent number 3 and respondent number 8, either due to collusion or mere gross negligence, have failed to consider the sale deeds which have been executed on the unregistered
Insufficiently stamped paper.
Sufficiently stamped papers. The provision under the Karnataka Stamp Act, which mandates that the document must properly be stamped, and if not properly stamped, then the same should be impounded. The respondent 3 and 8 have not adhered to the such provisions, due to which huge loss to public exchequer is being caused. Be that as it may, we are of the considered view that the complaint of the petitioner shall be first considered by the state government, that is respondent number 2, second respondent through the Secretary, Department of Energy, Government of Karnataka, Principal Secretary, full stop. The petition as such is disposed of with the observation that the petitioner shall make a complaint in this regard to the second respondent within a period of 10 days from today. In case any such complaint is filed, the second respondent may look into the matter and take appropriate action in accordance with law expeditiously.
Number 25, Ramesh Nayak, here, party in person.
I'm the
I appear for the second respondent, City Corporation. We have filed a status report on the last occasion regarding the maintenance of the roads. This matter pertains to the maintenance of roads by the second respondent, City Corporation. We were directed by this honorable court to file a status report. But accordingly, we have filed the status report, and all the roads,
Yes, what do you say, Mr. Nayak?
I have not been provided with a copy of the report. I will.
What can be done? You don't come to court.
we have served it online.
You don't come to court. And e-service you don't get.
They have not served a copy on me, my lord. They have sent by WhatsApp, which is 150 pages. They said they will serve on me. It was not opened. Kindly, if I'm provided with the copy, I will respond on that, my lord.
Why don't you come to court? You are a practicing lawyer.
Yeah, I will come, my lord. I will come.
We will provide a hard copy. online, my lord.
And kindly
The-
send it to my emails
Respondent
at
may
least,
provide-
sir. Or
Respondent may provide a physical copy of the status report to the petitioner who party in person list in the month of July.
much obliged.
26.
My lords, I appear for the petitioner, my lord. Also, I seek a small accommodation for filing my rejoinder.
Counsel for petitioner press for is allowed 2 weeks further time to file rejoinder affidavit list in the month of July.
Gratefully.
Appearing for the petition in this case, my lord, for a week's accommodation, my lord. Winner is held up out of station.
Attend on the request of counsel for the petitioner list again.
28, I am appearing for the petitioner counsel, my lord. Notice has
Yes.
been ordered, my lord, and reply is yet to be filed. If they want to file reply, my lord.
Service report.
Wakalat is filed. Learned counsel has filed Wakalat.
Not present.
He's not present.
Bhaskaraya.
Counsel for first to third respondent as well as counsel for fourth respondent are not present. Adjourn. You're not responding. What can we say? AG is present for first respondent 1 to 3. However, counsel for respondent 4 is not present. Adjourn. List again. Yes. Is there any urgency? The appeal has been admitted. Adjourn. List again in the month of July. Yes. Huh? Yes.
Using stone crusher activities, petitioner has already obtained license under the Stone Crusher Act provisions. That is at annex D, page number 58.
Is it covered by any order of our order?
That is at annex F, page number 40.
Page?
Page number 40.
Yes, what do you say?
That case, not the petitioner contended that there is no format for filing online application. But now there is a format for filing online application. They have to make 13 declarations.
He has already filed. He has already filed an application. No.
Application. He just filed a representation seeking for conversion of land. He has to fulfill the requirements.
Then
Annual application. My submission before OCC is there is no format to be filed through online.
at the time when he had applied, at that time there was no format. Now you have made it,
Online
isn't it?
There is no format to be filed under online in set of section 95(9) conversion. My learned friend did not produce that format that is applicable for regular NE, that is 95(2).
The order.
Same. We'll pass the same order.
Why the same order? Why not?
Let him fulfill all the conditions specified in the. he has to fulfill all the conditions.
Just look at that format, please. There is a format. There is one. That application is only a representation. On the ground that there is no format. The Lordship will get it annexed East, page 6.
That's it. Not even application.
No, this
See page 44, the order. In that also the application for conversion already pending. This is what his case is.
That is in respect of another application,
On payment by as demanded by the Deputy Commissioner.
not this application.
Shall be deemed to have been granted.
No, deemed conversion under section 95(9). Earlier in the in our order, format, what you call format application was not filed.
Not filed.
He had filed representation. We have said that you consider it as per that order. Same thing you do it here also.
At the same time, he has to declare, he has to file an affidavit like this. That is the requirement.
बढ़ा देंगे उसमें condition और बढ़ा
Right. All right.
Same order. This page 40. In this, add one more condition that the petitioner may fulfill the requirement of declaration or any other thing as per the prescribed format. Same order. First, same order.
He himself has produced in another case,
How does it make a difference? Now your application would be considered. In addition to that, if any declaration is required under the prescribed format, that you may also do it. This is what we have said.
No, sir. What he is saying is deemed conversion.
There is no format.
There is no format because they have submitted it. Within that period, if they have not done it, is deemed. So now if we say as per format, one more application. Now if we say as per
consider
format. No, we have said deemed. Sir. We have said deemed.
That provision.
No, sir. We have said it's already pending. Now deemed conversion shall be deemed to have been granted. Consider the application.
The prayer for the application is
Can clarify.
Right. So now we know.
Format is that not, he has to declare that he is the owner of the land. That is the primary requirement. He has to produce all the documents before the authorities.
We'll
add one condition.
We'll add one more condition. We'll add one more condition subject to you. See, we'll retain this order. You also petitioner. You also add one more thing. Petitioner is also directed to
make the declaration,
as prescribed.
Then same thing. No. That. Are you not the owner of the land?
And this is a case where not I'm seeking deemed conversion under section 95(9). For 95(9), they have to automatically they have to issue the.
Then you will have to challenge this format.
Sir, surely. Kindly hear us. Now, I can apply for deemed conversion. I can give an application. If they don't give deemed conversion, doesn't mean I'm entitled to. There are certain documents, facts which I need to tell them, right? So, subject to you providing all those details, you will get deemed conversion. Subject to you providing all those details.
Providing those details, he is not requesting this court to file online application.
No, sir. We have not said file online application.
We are not said your application would be considered. You will also give the declaration. That is all.
That declaration will be filed through online only. That's the only thing what is contention. Because this honorable court has already held a paragraph 7.
He has to satisfy the authorities by providing all the documents of title and all the other requirements.
He has to fulfill all the requirement, then only authorities will consider.
Where are those requirements? Please show us the requirements. Show us the requirements. What? Instead of one more round of litigation.
Unnecessarily.
Show us those requirements. We'll put him on terms. Land Revenue Act.
95-9.
Five.
95 subsection 9.
That we have considered.
Subject to obtaining lease or license or working permission under the said enactments. That's all. Where are the other requirements? One second.
Whenever
Mahendra, whenever any occupant of the land, right? One second. So, first condition is he has to be an occupant of the land. Number one. Number two, that land should be assessed or held for the purpose of agriculture. Two conditions, right? So these two are the conditions. So subject, we will say petitioner also directed to produce documents in accordance with section 95(9). That's all.
Okay.
Same order. Petitioner is. Sir, we are not saying format, sir. Bardu illa re. We have not said so also. We only said in compliance of section 95(9). That's all.
What are the format? Change that last condition. Instead of that, as per section 95.
95(9).
Fulfill the requirement as per section 95(9). Instead of format, you say 95.
95(9).
Same.
Even though what the respondent number 3 has not taken any steps either to consider or to take decision, therefore not petitioner is not. Section C is the application, which I filed it on 21 legal form for seeking the quarrying license.
This application has been filed pursuant to any advertisement.
I filed this application for seeking grant of license. Not the respondent number 3.
Right has been done.
Competent authority has to take steps to consider my application, which this authority is not taken steps.
Is there any right has been conferred on you to move an application by moving an application?
Patta landowner, this is my land. It is statutory duty conferred upon the authority to consider and to take decision.
Yes, what do you say?
Lord, under rule 32, he is the patta. He has obtained consent from the patta holder, that is private land holder, for quarrying. He made an application and he has to fulfill certain conditions. Statutory clearance he has to obtain. Then we will process it. We are filing an application.
Have you communicated? Have you informed him? That is what
I have to seek instruction.
you communicate him, tell him that what are the requirements if he fulfills, and take a decision only. Why you are keeping it pending?
For 1.5 years.
What for you are keeping it pending? You communicate. If they fulfill the requirement, then take a decision. Otherwise, reject it.
Under 8 Rule 5, it is the statutory duty of the authority to get NOC.
The writ petition has been filed, seeking following relief.
Which has not obtained any NOCs.
The counsel for petitioner submits that petitioner is the patta owner, patta landowner of the land in question.
He has obtained consent from the patta.
This is what he is saying. We are not deciding it. He has moved an application to respondent number 3 to consider for grant of quarrying license for extracting ordinary building stone, which is a non-specified minor mineral. Full stop. The respondent number 3 has not taken any decision, due to which petitioner is being put to irreparable loss. Learned AG appearing for respondent, on the other hand, submits that petitioner is not the Pata landowner. He has only taken consent from the Patta landowners. In case petitioner has moved any application for grant of quarrying license, then also he has to fulfill certain conditions, and only thereafter his application can be considered. Para. It is for the respondents to consider the application of the petitioner. In case any requirements are there to be fulfilled before the application is to be considered, then the respondents shall inform the petitioner about the said requirements, and in case petitioner fulfills those requirements, then only thereafter the respondents shall consider the application. However, the application of the petitioner cannot be kept pending indefinitely. As such, the respondents shall inform the requirements, if any, for the application to be application of the petitioner to be considered, and the petitioner shall thereafter fulfill those requirements. In case it is so, the respondent shall take appropriate decision in accordance with law expeditiously. The entire exercise shall be completed within 3 months. The writ petition with these observations disposed of. Yes, you find objection?
I pray for 2 weeks.
Granted, AGA pays for the allowed 2 weeks further time to file a statement of objections. Placed in the month of July.
Register to print the name of learned AGA for R1.
Learned registry shall print the name of AGA for R1. Same matter.
34,
Huh?
Respondents.
Yes.
We will take instruction from clients.
We are unable to hear you. What are you saying?
Appearing for the respondent, my lord, we will take instruction from client. Kindly granted this.
At request of learned counsel for respondent, list after vacation.
July,
Relist during July 2022.
जून तक बहुत लगा दिया.
For the respondent.
Counsel for appellant, on the request of counsel for the appellant, case is urgent, list in the month of July. Urgent.
Right, Lord. Lord, export order, actually.
We heard fine.
कोई एजेंसी हो सकती है नहीं लगा दे.
2 months time.
filed a PI lot for this court. Containing not the AS officer posted as a decision which did not exercise the power. Karnataka Land Revenue Act. Court. Lot. Watch the order. Annexure F lot. Kindly see the order. Page 38. Not the 28/11/2019 order, annexure F lot. Kindly see. That order not in existence. It's a not fabricated order. Kindly see what the order, actual order passed by the state government. Pursuant to the order of the CH, my lord will find page 150. That is the order not which is existing. Kindly see the note. That's why what I request you also work on the minds of the petition.
Sir, impugned order annexure A, you are not a party.
I'm not a party. I'm not a party.
So you want opportunity to be heard by restoring this petition.
It is restored, my lord. When really
Right.
What is the stand of the state government? Whether it is a cadre post?
But insofar as the petition is concerned, my lords, in that regard, there was a regulated, there is a writ petition before this honorable court, wherein it was directed.
The present petition applicant, they are not IAS officers.
Yes.
They belong to KAS officers, cadre. Now, by that order in the PIL, the court has provided that only IAS officers shall be posted as special deputy commissioners in the urban areas. Now, their contention is that they have been affected by this order because they will not be considered for posting as special deputy commissioner. This is your case?
As of now, there is a government order under section 9 of the order.
Government order 28th of November 2019
One
is.
submission, my lord, as far as the petition
What is the
concerned-
stand of the state government? This is what we want to
One
know.
submission. Before that, my lord, we have not disturbed the petitioner at all. She even now continues to be additional
We are
special
not
deputy
concerned.
commissioner.
We are not concerned. Only issue is whether the state government says that only IAS officers are to be posted as special deputy commissioners, or these officers, state government officers, can also be considered. That is all.
My instructions are that, my lords, in compliance of the order, we have done this, but section 9 is there, my lord. Section 9 of the Act says that additional
special application can be posted.
has to be
Section 9 is not a land area.
there.
Number 1. Whenever state government, section 9 notice like this, considers that for any purpose, it is expedient to appoint special deputy commissioner for this district. It may, by law, appoint a special deputy commissioner for such district, for such purpose, for such period, that is specified in the notification. Special deputy commissioner shall exercise such powers and perform such duties as are exercised or performed by the deputy commissioner in the district or part of the district under this act or any other law for time being force as the state court may direct. They can exercise the power of a deputy commissioner also. If the notification specifies. How the respondent too can maintain this PI, the service matter, number 1. Number 2, my lord, annexure F is a non-existent order, fabricated order. Kindly see the file, original file. Such an order is not there in the state, passed by state government at all. 28/11/2019. No, my lord, number 1, PIL is not mentioned. Number 2, section 9 not supports the petition. Number 3, my lord, non-existent order, fabricated order is first. It is not bona fide PIL at all. Kindly see one election as not in the original file, not whether such an order is existing in the state government. Annexure H is the order, page 150. Therefore, Supreme Court refers this order and says not permitted to file review petition. Page not 150 is English translation. Kindly see one original file not Annexure F order.
No, Annexure F is contrary to Annexure D. What is Annexure D?
Annexure D is the order, right, in the review petition, in the lease petition, right? This court, right, when my transfer posting a special duty through question by somebody, right? That was brought, this court held, right?
Sir, 10/10/2014 government order.
Yes.
Is it correct or not?
Yes, sir.
It is correct.
But what is not correct? This code in a PIL, what the
It's all right, sir. Ink page 36.
Yes. Yes, that 36 is there, right?
Deputy Commissioner, Bangalore District.
Yes.
Special Deputy Commissioner 1, Special Deputy Commissioner 2. They are only IAS cadre.
IAS cadre, it can be declared by the only for a period of 2 years by the state government. Thereafter, it cannot renew. The central government power is like the Union of India, not by the state government. State government can declare not IAS cadre. It can send it after 2 years. If it is approved only, it can be IAS.
No, sir, we are not following. Deputy Commissioner is shown in the table. Special DC is shown. Special DC 1 is shown. 2 is shown. You don't come under any of these three. Right. Then what happens?
Therefore,
then if that is correct, then you can't take up any of the subjects mentioned in the table.
Correct.
Right. And then what?
But the question is not whether state government has power to encadre to IAS under law. It is only not central government which can approve it. Thereafter, it can be encadred.
Sir, operative portion, para 12. Okay, kindly read from para 11 onwards, ink page 37.
When prior to the government order 10/10/2014, ordinance bench of this board, in the opinion of of the public interest litigation, disposed of 26/8/2014, had taken note of the notification 10/10/2011. We had observed that FT Commissioner and Special FT Commissioner had to exercise their power in terms of the government order. Earlier and thereafter, the order dated 10/10/2014 further clarified that position, the operating position of which is extracted above. It is not brought to our notice that there has been any modification of the order dated 10/10/2014. In the circumstances, DPR had post officers of the IAS cadre as special deputy so far as Bengal urban discharge their duties under section 136(3) and other provisions of Karnataka land union. In circumstances, we hold that Annexure F order dated 28/11/2019, that is a non-existing order, replicated order, filed before this court. That is what? 28/11/19 order is plus 350. That is separate notification for creating one special deputy commissioner for KS under section 9. And if you want that, Annexure Act 815.
Thought, sir. Page 115 is contrary to 10/10/2014. Isn't it?
If the government has power under section 9, it can post a deputy commissioner or special deputy commissioner, both. And it is section 9.
No, are you saying this 10/10/2014 order is superseded?
By 28/11/2019 order, Annexure Act.
It's only a clarification.
And if you want that is 20. I'll read that order. I'll read that. It will indicate. Proposal under reference number 1 has been examined. State government will order dated so and so 10/10/2014. That is referred. That is what?
No, it's only a clarification.
Yes, my lords.
But not a, so if 2019 order is a clarification of 10/10/2014 order, then kindly come to learn its single judge operative portion. Annexure F is contrary. It is not contrary. It is clarificatory.
No, not that. Annexure F is not there. It is fabricated order. kindly original file, not there, my lord. Annexure F, which is point with this court, is non-existent order.
Sir, Annexure H is there, no, sir?
It is there. It is not what is the notice of this court while discussing PIL.
Sir, doesn't matter, sir. It is referred to Annexure H, 28/11/2019. It is there.
Yes.
So forget let us not pay importance to F or H.
Yes.
What is referred to in para 12 is Annexure H from in your paper book as 28/11/2019.
Yes.
That is held to be contrary to 10/10/2014.
No, that is not held to be contrary to the order. Kindly the original file.
Sir, para 12,
What it is
Annexure H. Let us read F as Annexure H.
No, it can't be read like that because annexure F in the original file is different. Kindly the original file.
Lord,
The red paper. Kindly the red paper. It is different.
Page 117 may be seen.
No,
Why
not
they
that.
are aggrieved
For a
by
moment,
this.
kindly the annexure F. Such an order is there in the state government. Annexure F is non-existent order.
Understand. Grievances that he is affected and therefore she should have been heard.
On that, we have no
We'll send it back. We'll send it back.
As far as
The Honorable Supreme Court has recognized their right to participate in the proceedings. We'll send it back. You file your objection.
For a moment, kindly the annexure F.
We are
Sir,
not
we'll set
deciding.
aside.
We are
We'll set
not
aside the order.
deciding.
The order in PIL will set aside and we'll reopen it. We'll restore it.
And let you move a application for implement, and you will be heard there.
Yes.
Bas.
Some typographical error or some due to inadvertence this has happened.
We are not deciding. Like, उसी ground पे कर दो, there is not.
All right.
This review petition has been filed
4,
pursuant to
We'll write
Supreme
it,
Court
sir.
direction.
We'll write it later. Operative portion. In the result, we pass the following order. Petition is hereby allowed. Impugned order dated so and so in WP number 10850 of 21 dated 8/7/21 is hereby set aside and the petition is restored to file. Review petitioner is permitted to be implemented as additional respondent number 4 to the said writ petition. Full stop.
They have implemented this order. But directed to restore
We are setting. No, we can't do that.
We do that.
the.
We will have to hear that PIN.
But they have
The main
implemented
PI, sir,
by in a content petition.
sir, we have set aside this. In the main PI, you file applications for whatever reliefs you want. Allowing the petition.
Yes. Right.
Your Lordship, I appear for the petition on this matter.
Because the petition in the first minute.
37.1, I represent my colleague is appearing on this.
Yes.
Lord's pleadings are completed. Violence of BBMP Act is under challenge. It may have to be heard, my Lord's.
So we are here to hear matter.
It may be fixed.
July.
The request of counsel for the respondents. AGA informs that Advocate General is to address the court on behalf of the respondents. He is not available. On the request, he is adjourned. Placed in the month of July.
38.
तो कम अगे पास ओवर भी तो है ना
Pass over
पड़ेगा
it.
Complaint in this case.
कार्ड आ गया
Deposited the amount well.
posted for hearing
Hearing. List for hearing.
in the month of July.
July.
Chalo. After lunch.